You're seeing estate planning for parents and grandparents raising minor children. How about that, Mandy? Am I on?
Yep, that's what I'm seeing, Marcia.
Okay, that's good. Well, I could tell you stories about the difficulty I had getting on today and even wound up on twice. And I thought, well, that's not good either. So I would like to say hello and welcome to our estate planning for parents and grandparents raising minor children. That's a series, but today we're going to be discussing what you can do with a will and what you cannot do with a will. And the voice that you're hearing is Marcia Gadding, and I'm the Extension Family Economics Specialist here at Montana State University. And we're a part of the university system that, they used to call it service. And then the term was outreach because we outreach across the state of Montana. And now we are engaging you in a different type of way. Instead of being live, we are doing webinars, which I think a lot of us have gotten used to over the last couple of years. And I would like to introduce my co-host for this morning, and that is Mandy Reed. And as you can see, she is there, and she is our Wheatland County Extension Agent. Any of you that know where Wheatland County is, it happens to be Harleton. I just drove past there last week when I was doing a program in Lewistown. Now we have, I can see right away that I have the wrong slide set because we have more than 6 Montanans involved. So if you'll just pardon me for a minute, what I'm going to do is make sure I get the right one. Okay, if you just give me another second here, I'll get this figured out. Okay, that is the one that I updated this morning. Uh, and oh my goodness, we've got 47 of you out there. So I'm embarrassed in front of 47 people from the state of Montana. So my apologies and welcome to our webinar. And I was excited to see that we have 9 folks from out of state that are interested in this webinar. So yay for you folks clear out there in Virginia and Oregon and California. Great to have you in Montana. Now, we've had a special request from webinar participants in the past. And if you've done webinar or seen webinars, you realize that there's challenges sometimes because people can be boring and I don't want to be boring and neither does Mandy. So they want us to be motivating. They want us to be excited, get you excited about doing estate planning. And they are saying, don't put people to sleep. Okay, so we have for you some top 5, what we're calling engagement tools. And those engagement tools are to get you involved in what we're teaching and let us learn a little bit about you at the same time. So one of the things that we want you to take advantage of is the chat room. That chat room is over there. It's for you and it's designed for you to ask questions as we go along. And yes, that was a real question mark looking pine drop. My husband and I are out driving around. I see it. I go, you got to stop. I want to use that in one of my presentations as a question mark. So we're going to give you a practice session with this. What best describes you in your role of raising minor children? Are you a married parent, a single parent, a married grandparent, a single grandparent? Maybe you're a foster parent. Maybe you're a member of a blended family. I tried to come up with as many as we could. So if I didn't do a good job of describing you, I encourage you to describe yourself in the chat room, please. Excuse me. Okay, Carrie kindly brought that up. Okay, Carrie, if you could please give me the results, and we'll see if we've got some percentages there. Okay, we've got most of our participants are a married parent. So that's what we'll go with. I make sure that I've got married examples and single examples just in case. Then we will take a look at our next slide. And what that is telling you is that at the end of this session, we are going to have a couple of special guests. So we've got Mandy serving two roles today. She is being a co-host, but she's also going to give us some perspective on estate planning for minor children and some of the things that I think she'll say I did right. And then maybe there's a couple that she might say, I wish I'd have done it sooner. And we also have Kelly, and Kelly is going to be a part of our series as well. And Kelly happens to be from the Butte Silver Bowl County Extension Office. I also decided that it might be fun for you since, well, you'll see. I have trivia questions, and throughout the presentation, I'll ask a few of those, and then the winner will get one free wildflower card. Okay, so my trivia question for you is, what is an able account? And you can enter that in the chat room. And we have a system there where there's timing. And so we'll know whoever got that question right, and you were the one that will be awarded a note card. Now, why am I sending note cards? Well, I like wildflowers. And the last few years, I've been able to use these in my presentations to introduce topics, to help you try to remember. And I'm trying to be a little bit clever because I really don't tell jokes. My husband says, don't tell jokes. You don't do it well. So I'm going to use wildflowers. And basically, these wildflowers are to help you remember some of our important information about today's webinar. Now, we've got a flower there. Yes, it's really a flower. If you ever get to Yellowstone in May, you'll have a chance to see this flower. So my second trivia question for you is, what is the name of this wildflower? Okay, so those of you that have access to the chat room, let me encourage you to clip on that and write what you think the name is. Now, don't give me any of those Latin names because I wouldn't know if you were right or wrong. But if you use a common name, I think I'd know. And just to help you out, I'm going to give a hint. Are you ready? Moo. Okay, that's the only hint you get. And there we go. It's a steer's head. So what that tells me is that Mandy and I want to steer you to some solutions to some concerns you might have about raising and doing estate planning for your minor children and grandchildren. And then we also want to make you aware of the laws that Montana have about what happens to your kids, what happens to your assets if you don't write a will. Okay, so Mandy, why don't you share with us some of the typical concerns that parents and grandparents have about legacy planning for minor children?
All right, well, thanks, Marcia. Yeah, I'd like to share with you some of the concerns that we've heard from other participants in the past and some concerns that I know I had when I first learned about estate planning from Marcia, actually. So one of the concerns that people have is the funds. Where are the funds going to come from to help provide for my children if one parent passes away or if both parents pass away? So one of the other concerns to consider is who's going to manage these assets? How will we make sure that those assets are protected and there for the children as they age and mature to help pay for school and college and homes and things like that as they age?
Well, and Mandy, do you have an age that you think your kids reached financial maturity, or have they yet?
I don't know. It's interesting that you ask that, and it's easier to find that looking back than looking forward. I was thinking about that. I might make very different decisions today as my children are both older, but looking forward, I think this is something we struggled with. So I think it's really hard to say and something you have to definitely consider. And I would probably make different, I would say my daughter might reach that with her business degree a little sooner than my son. Another concern is who's going to take care of your minor children if one parent passes away. So this could be a very difficult conversation, but something you definitely want to consider. Is that going to be the surviving parent? But what if that surviving parent isn't capable of taking care of the children? We know that there's lots of different situations to consider there. Another concern would be, what if both parents pass away? Who is going to take care of your children? That could be grandparents, that could be a sibling, that could be friends or other family members. So these are just some of the concerns that we've seen. So I don't know if you recognize this flower, but this is the bitterroot flower, which is Montana's state flower. And Marcia's captured a really gorgeous picture of it. And we have this up here to help remind you of the bitterness that can happen from a lack of planning. So if both parents die without a will in Montana, the state's going to make all of those decisions for you. They're going to be deciding who's taking care of your children, and they're going to be deciding who gets your property and how it's distributed. So let's take a look at an example here. We're going to call this our bitterroot family. And Dad has an estate worth $600,000, and we have 3 minor children in the household. So we have a question for you. What amount of the $600,000 will each minor child receive upon Dad's death if he passes away without a will? So you'll see your poll over there, and if you just take a second and enter that in, it's really easy.
Oh, and we probably should say, don't forget to hit the submit button. It's way down at the bottom of the page. And I know the first time I was doing this, I thought I'd answered, but I hadn't. I forgot to hit the submit button. Okay, Carrie, let's see what kind of responses we got from folks.
All right, so we had kind of a varied range of responses, from a few people thinking that the children would receive $100,000 each, to the children would receive nothing at all, and a few that thought also the $25,000. So that's excellent. We have a nice range of answers there. So the answer to this question actually is that the children will receive nothing, and that all of that money will go to mom. And so that, so
Sorry about that.
No, you're fine. So we can move to our next slide. So if both mom and dad die, by Montana law, the money is going to be divided up equally among the children. So if dad passes away and mom is still living, then that money is going to go to mom. And if both parents die, then that money is going to go to the children.
Yeah, and that's kind of what we're talking about, is if this does happen, well, what kind of choices planning wise could we do if those children are minors? You know, and that's why you folks are attending this particular session.
Yeah. So Marcia, could you explain to us what happens as our family, our bitterroot family, ages and later in life?
All right. Well, we all start out here, maybe husband and wife, and then there are the kids, and the kids get married, and then they bless you with grandchildren. So we've got some of you out there that are raising grandchildren, and this is a happy family. But unfortunately, we have tragedy that's struck this family more than once. Because what happened in 1999 was the son was killed in an airplane crash in western Montana. Then we had the unfortunate accident in eastern Montana where the daughter and her husband were both killed in a car accident. So they left 3 children that are minors. Well, then what happened is grandma and grandpa are raising these kids, and then grandpa dies as a result of a heart attack. The last survivor is grandma, okay, also the mom, but in this case, she did not write a will. You know, we just sometimes don't want to deal with writing a will because we don't want to talk about dying. We don't like to think of ourselves as something happening. So she didn't get around to doing that will. So I want to show you what the state of Montana is going to do then about what's left of the estate, which was pretty substantial. So with her passing away in 2015, I've got a red lightning bolt there on one of the green children, the D. So I want to know what fraction, if any, does that grandchild receive? Okay. And if you find the poll is, in my case, it's covering up the sample, but I think yours is on the right-hand side of the screen. So I hope you could see the drawing and tell me what fraction, if any. Is it going to be nothing, you know, like 0? Is it going to be 1/6, 1/8, or 1/9? So just imagine yourself in this situation. You don't get around to writing that will. And here comes the state of Montana saying, hi, this is the way the property is going to be divided. Okay. Don't forget to hit submit. So Carrie, what's our result today? Okay, it appears there that we have got 1/6 by 10% of you, and we've got, well, we got a tie. Everybody is equal choice, what we will call equal opportunity, so to speak. But we have 70% of you that are not responding. And that has my curiosity. Do you not know how to respond? If so, we've got something at the web to show you if you're using your smartphone. In my case, the phone is smart and Marsha's the one that's dumb trying to find something on it. So you may not be able to find how to do the polls on the phone. Go to our website because Carrie has put some pages up there to help you with that. So we need to know what is right. Which of you were right? Okay. And we're going to see that the 10% that said 1/9 are correct. So you see the Bitterroot family here, the minor children are asking questions. You know, the turquoise one over there is going, oh, well, I got a third. Doesn't even really realize what that means. And we've got 2 pink grandchildren that don't receive anything. And they're wondering, well, didn't grandma and grandpa love me as much as they love the other kids? And then the other 3 green children are, well, if they're not asking the question, somebody else is. Why did they only get 1/9? What's the deal? Okay, well, here's the deal. What we've got is, I've got a 0 on the sun. That is wrong. That should be 1/3. Where's the brain that I didn't catch this? Should be the sun, 1/3. So why is it that way? Well, it's called right of representation. This is the way Montana distributes the property if there is no will. And if you're sitting there thinking, oh, I have a will, I don't need to listen to this part, take a look at that will. Because in many states, what is used is the Uniform Probate Code. And the Uniform Probate Code, even when you do a will, the attorney may use a term that's not familiar with us, and it's right of representation. So let's see what that means. Look at the kid that receives a third. That's our turquoise kid. Well, we could look at him as representing, in a way, his dad, because the dad would have received 1/3 if he was alive. Okay? Now, The son that says 0, no, 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 that's a third. You see, the son did receive the third, and because he did, the 2 children did not receive that. And then we've got the 1/9, because a third of a third is a ninth. So is this what you want to have happening? Maybe it is in your family, but maybe you would decide that you just want to skip a generation and you want to leave it all equally to the grandchildren, which of course you can. Or maybe in this case, since it was grandma raising the grandchildren, maybe it's because there would be more needed for those 3 green ones, doing a college education, doing some other things like that. So parents and grandparents, you just need to decide, do you want right of representation to apply in your family situation? Now, here are some other flowers, and I think they're really neat. I mean, don't you wonder how a flower knows to look like that? But each one is different. And I used this in one of my earlier presentations, and it's larkspurs. But I had a lady that was there and she was so upset. Oh, Marcia, you shouldn't use that. And I go, well, why? She said, don't you know it's toxic? And I love that because sometimes we have toxic family relationships that result from lack of planning. And we're going to look at it in this case of who gets the kids. Now, I could say that nicer, like who receives custody, whatever, but it's who gets the kids, because we're looking at the Larkspur family here. And there are toxic family relationships that happen. And here's the family. We've got grandma and grandpa Larkspur. We've got brother and sister, the siblings of the purple mom. And mom, uh, her husband died. So she is saying, I've got this minor child. I've got to do some planning. So what she did is she had a conversation with her family that's next door that are called the Green Gentians. Well, the Green Gentian family said, yes, we really, your kid is wonderful. We just enjoy how he plays with our kids, and we're willing to take that on. And so the mom told everybody this is what she wants to have happen. She told her parents, she told her brothers and sisters, and she didn't write a will. So what happened is, doggone it, mom dies. She didn't write that will. And what happens is we've got a custody fight, because the Green Gentians go to court saying, well, she wanted us to have them. And grandma and grandpa are there. And grandma and grandpa said, I really feel we should be the ones. And in this case, the judge awarded custodialship of that child to grandma and grandpa. And see, in this case, the mother's wishes were not honored. So by writing a will, you can nominate a guardian and you can avoid toxic relationships. As a matter of fact, you can appoint or not appoint, but you can nominate a guardian and a conservator. And Mandy, that reminds me of a yellow monkey flower. Don't monkey around, okay? Explain more, because I'm using these terms guardian and conservatorships in a will. What does that mean?
All right. So one of the things that we can do that helps us avoid those toxic relationships is to nominate a guardian in your written will to take care of your children. So this is going to help you avoid your own worry and worry from your family, because you're going to know that your family that your children will be cared for by the person that you nominate.
Yeah, and 99% of the time, Mandy, I hear the judge is going to go with who you nominate. It's very, it'd have to be extenuating circumstances that they wouldn't honor your nomination.
And the other thing that you can do is also to nominate a conservator in your written will, and that's the person who's going to manage the assets. So this is going to ensure that your children's assets are managed wisely for their future, according to what you specify in your will. It's also a really good idea for you to nominate a backup guardian and conservator, because we know that life changes all the time. We've learned that, especially in the last couple of years, But I think before that also, I just know looking back on my own, the wills that I have written, how much changes in between. So we know that people get divorced or remarried, their circumstances change. So the people that maybe said that they could be the custodian or conservator might not be able to do that. And you don't want to have to rewrite your will each time. So it's a good idea to think about who that might be. One detail, Marcia was talking about this a little bit earlier, is that we nominate our guardian and conservator, and then a judge is going to make that decision and appoint them. And Marcia is exactly correct. Most of the time that the judge is going to honor our recommendations and appoint who we've asked for in our will. There's one thing to think about though when they appoint your guardians for your children. If your children are older, specifically at the age of 14, their preference is going to be taken into account when the judge is making this decision. And that's just going to give them an opportunity to, there might be some sort of a situation, an extenuating circumstance that you didn't know about, why your children might ask for a different guardian. So specifically, a guardian is given the responsibility of a parent for children that are under the age of 18. So they're going to have those parental responsibilities. A conservator is going to manage the assets and the money for that child's needs until they reach 18. I always thought of this as a great balance because I thought of specifically in my own family, and I feel like I can absolutely share this. My sister has a great heart, great heart. She would be a great custodian for my children. She's terrible with money, terrible with money. And so to make her job as being their guardian, to make her better at that job, we definitely wanted a conservator to help her manage those assets. And so I think this is a great balance for protecting your children. You can change who you've nominated as your conservator or your guardian for your children. And there's two ways you can do that. You can write a new will if that's something that you choose to do, if you need to update your will, or you can just add a codicil. And that's basically like an amendment, like a change that you've made to your will. There's also another alternative that you can use, and you can leave assets to your children under a custodian under the, you can leave assets to a custodian, under the Uniform Transfers to Minor Act. And we have another trivia question for you. So I definitely hope you are taking advantage of the opportunities to win these beautiful, beautiful cards. But under the Uniform Transfers to Minor Act, a custodian turns over the child's assets to the child when they reach what age? And I think, do we want them to pop that into the chat?
That Uniform Transfers to Minors Act, when I go to trainings that the attorneys do, they call it UPMA. Well, it's a tongue twister, but it is a good one there.
All right. So the custodian is going to record the titles to property, manage any investments that you might have, and then keep records of all of the transactions. I apologize, I'm a little tongue-tied this morning. Until the child reaches 21. And at that age, the custodian is going to close out the accounts and transfer the property to the child. Once that custodianship terminates, the child has those assets and they're not really protected anymore. So if they've made unwise decisions, those assets can then be used to be applied to their debts. Just something to think about as you're setting up the age of financial responsibility. Another thing to note is that adoptive parents have the same legal rights for their adopted children as for biological children. So they're viewed the same. And foster parents have limited rights by state statute. So foster parents can't name a guardian or conservator for their foster children, but they can leave assets to their foster children. So don't monkey around, and make sure that you direct the assets to a custodian for the benefit of minors under the Uniform Transfer to Minors Act. So Marcia, can you give us an example of what could happen to an inheritance of minor children in a blended family?
Yeah, Mandy, I've heard a figure that 58% of marriages are in Montana are those that he has kids, she has kids. And so what can happen with that? Well, with that, I'm going to use a white mule's ears. Okay. And why white mule's ears? Well, have you heard this phrase? Mom or dad is stubborn as a mule. Yeah, I bet I said that a couple of times about my dad. But let's look at these circumstances and really see if dad is as stubborn as we think he is, or is he a smart man after all? And you see, this is what Montana is going to do. And here's a dad that is saying, why should I have money that I'm going to put aside to do a will? You know, what is going to happen is these two kids are going to be fine because the state of Montana is going to treat them equally. So why pay $1,000 or 800 or even 600 for a will when I know that's going to happen? Well, yeah, indeed, Montana law will allow those two children to inherit the property. But I was doing a program actually for a high school, and you might think that this is kind of a heavy program for high school students, but I had one student in the class, and she just kind of raised her hands like this, and I said, okay, you've got a question. You know, I'm excited. She's got a question. And she says, well, my dad is dating a woman, and she's worried that her dad is going to marry this wow wow floozy from Bozeman, or Billings in this case. Okay. And well, I went through an example with her and I said, well, this would be what would happen. And so here we have dad, and dad, to show his love for, I'm not going to call her a floozy, I'm going to say this new wife, and he put the property in joint tenancy with right survivorship. Okay. And then let's say dad writes a will. And in his will, he's going to say that I want my share of the joint tenancy property to go down to my two children. And he says, I've dated the will after the joint tenancy was formed. So therefore, the will is going to take priority. Well, this is now a blended family. And we discover in this situation, he has kids and she has kids. Okay, so let's say that, dad has said all these things. I've written this will. The will is going to take care of it. So, honey, you don't need to worry about this. And I'm thinking, oh my, because if dad dies, will his kids get the property? And I know you're sitting there in front of the computer and you'll feel funny saying what the answer is, but is the answer a yes or is it a no? I hear a lot of no's. Yeah, you're right. And the reason being is when dad the mule dies, the wife is going to receive everything that's in joint tenancy with right of survivorship. So if he put the checking account, the savings accounts, the house, the land, everything in joint tenancy, she receives it all. And he has not achieved his estate planning goal because his two purple children there, they get no property whatsoever. She receives it all. Okay. Now let's do the worst case scenario. She dies. Now, where does the property go? Oh, I bet you've already got that one figured out, don't you? Yeah, it's going to be her children. If you were his children, you feel even worse because not only did she get it first, but after she died, it went to her kids. It didn't come back to them. So that can be a bad situation. Or here's one that's even worse. I know of a lady that did that, and she married the good-looking hunk in Missoula. And I bet he was a grizzly, Mandy. Anyway, what happened to this case? This spouse also put the property in joint tenancy with her new husband, and she died. The hunk from Missoula received it all. So what an unfortunate situation. We need to know. And that's why MSU Extension has Mont Guides. We have these fact sheets so that you're aware of what happens with this joint tenancy property. We have wills, and that's what's listed at the resource page for the Minor Children website. This is where you registered. And if you look on the left-hand side, there's a box, or there's a line there that says resources. Go look at those resources and use those as a review for this particular session. So joint tenancy with right of survivorship may not be the best choice if you want to provide for your children from a prior marriage. Okay, Mandy, we've got a cool tool with MSU Extension that's been developed to help families see what happens with their property if they don't write a will. And what is that?
Yeah, this is a great tool. And so we have the Old Man of the Mountain,
And
and
yes, this is really a flower. I can't believe the name.
yes, and that's to help us remember that estate planning is not only for old people. And and then this flower is actually has this cool name of Youth on Age. And so we want to challenge young people to think about, or young people think that they are invincible and they're not going to die. And so they're hesitant to write a will or engage in estate planning. But unfortunately, we know that death can really occur at any age. We live in a place and a time where there's a lot of things that happen. And dying without a will in Montana or in any state leaves your family vulnerable to those things that we've talked about before. So Marcia has designed a fantastic website that has, it's interactive, and it will answer questions, yes or no questions, very easy yes or no questions that will help show you what will happen to your assets if you happen to die without a will. And so you're just going to go through these examples. So the first question is, do you have one or more living children? And you're going to click yes or no. So in this example, we're going to say yes and click there. And then it's telling us, the website's telling us as we go through that we've indicated that we are single and that we have one or more living children. And so then, do you have one or more living grandchildren from living children? And so we're going to answer yes to that one also. And then this wonderful, cool tool program is going to show you in this diagram how your assets would be divided if you happen to pass away without a will. And then there's an example on the bottom that's going to explain it and give you that text. So the program is actually set up to help cover many different family compositions. So there's 13 compositions for single people and 22 for married people, because we know there's lots of different family combinations out there. So for example, this is one way that it's going to show you how your assets are going to be divided. So if you have a child, and then you have a spouse, and you have a child, and your spouse has a child, and you have two children together. So his, hers, and ours, and a blended family here. It's going to show you that if you were to pass away, and how those assets would be divided. And in this example, your spouse's child that you have not adopted would not inherit anything out of these out of your assets. And you could see how that might leave some questions, and you're not there to answer those. And so if that's not what you intend, then you're going to want to write a will to make sure that your spouse's child, or that child, the pink one, is included the way you'd like it to be. The way you'd like them to be. So you can find this really cool tool on our website www.montana.edu/dyingwithoutawill. Or if you don't have internet that's fast enough, or you just like it on a CD, you can actually contact Marcia Getting, and her email address is goetting@montana.edu, and we can get one of those sent to you. And that can just be a really good tool to motivate yourself, or maybe to help you motivate your family members to get a will, so that your assets are divided the way you want them to be and protected.
Well, and Mandy, I'd love to take all credit for this, but I've got to say, I did the subject matter. No problem. But the real brains behind the site itself to make it interactive was Carrie. The one that I mentioned maybe earlier, is that Carrie Hayes is the one that helps with doing the web stuff. And the funny thing about this is we went to the high ups at MSU and they told us it couldn't be done. And Carrie kept working with it and she figured out how to do it. And I was just delighted. And so we have had to update the website a couple of times. Every time the legislature meets, I go, oh no, what will they do this time? And we update it. And then I run that past the members of the better section. There's the business, estates, tax, trust, and real property section of the state bar, because I want to make sure that what I'm telling you is correct. So anyway, I want to do a shout out for Carrie because she was smart enough to, and I couldn't even begin to do that, but I can do subject matter.
Absolutely. Carrie's a rock star. So thank you for bringing that up, Marcia.
Uh-huh.
Thank you both very much. That was very nice.
And so our tips from from youth and age, our old man on the mountain, is that if you don't have a will or trust, use this website to become aware of how your property will be distributed. That'll help you, and you'll know. You won't be second guessing or just making wild guesses. So Marcia, we're running close. We're running out of time.
Well, and what I think is that for once, we're going to have plenty of opportunity for folks to ask questions that weren't covered. Sure, we're going to have 3 more sessions, but we want you to feel free about asking any kind of question. We won't use your name with it. We'll just say, we've got a question here about such and so. And Carrie will share those with us, or Mandy, if you can see them. I can't see what you're saying. So if you have a question, make sure that you ask that. And I'm using here a lady slipper to represent how time can really go by so fast when you're doing one of these webinars. And I hope it went as fast for you that you weren't saying, oh, gee, this is so boring, because we want relevant information for you. And we hope that we really did steer you to some of the solutions out there to some concerns that you have. Because by writing a will, you can make sure that these minor children don't inherit the property at age 18, at that stage. And let's think about if we think about ourselves, I'm sure we can say, oh, at age 18, we were so mature. I see Mandy shaking her head. So she must have been one of those different people, because I'm sure that my folks would have probably disagreed with that. So, and then the other thing is that custodial account that's out there under the Uniform Act. 21. Well, yeah, we hope that 21 is more mature. But what I'm finding with parents and grandparents is that they're seeing, there's so much of life yet that they have not experienced, and we've got to find a way. How can we provide for them to maybe get those assets later? And that's why we planned one of our sessions that we're going to have to be on trusts. We're going to be looking at living trusts and testamentary trusts, and run through some of the advantages and the disadvantages of those, so that you can say, I want this child to have some maturity, so I'm going to maybe just give them the income. Or maybe I'm just going to give enough for them to go to school. And you might define school as further education. I don't care if it's welding or if it's going to MSU, or I must be fair and say U of M, of course, whatever. You can decide that in your trust document. So there's some reasons for grandparents and parents to be thinking about, if I don't want them to get it at 18 and I don't want them to have it at 21, you've worked hard for all of that property that you have, and you just don't want them to blow it, right? There was one kid when I moved to the state, he inherited a $2 million ranch, but he was 18 and he thought he was smarter than his uncles and everybody else. And he made some very, very unfortunate decisions and eventually lost the ranch. So let's not let our minor children run into that kind of situation. And then we talked about Montana's plan for your minor children and the transfer of your property. So we know that you die without writing a will. Montana's got a plan. And they had to do a plan because 7 out of 10 die without writing a will. So each state has their rules. And if you're in another state, see if they have the uniform probate code, see what's available from your extension offices there. And it may be that you'll find out it's the same as Montana law, or it might be totally different. So we have here my answer to the very first question that I had was, what is an ABLE account? And part of that was to be a little bit educational, to let you know that this is a tax advantage account for those with disabilities. And that allows you to have a savings account. Money can be placed in there and it doesn't kick you out of a program. For example, you may be on the child may be on SSI or disability income, some of those kinds of things, but they can still have this savings account that's an ABLE that will allow money to be spent for some of the things that would make life a little better for that individual. So Carrie, just offhand, did you see anybody that got the ABLE account question correct?
Marcia, nobody answered that question.
Nobody answered. Okay, next week I won't make it so hard because I'm sure a lot of us haven't heard about it. But if you know of somebody that happens to be in, happens to have a disabled child, no, a child who is disabled, excuse me, they might be interested in our Mont Guide on ABLE accounts. Under the Uniform Transfers to Minors Act, we did give the answer there. Mandy did, that it was 21, but that was after everybody should have already entered their response. And how about that, Carrie? Did we have anybody respond before we gave the answer?
We had one person respond.
And did they have the right year?
They did not have the right, they did not have the right age.
Oh, okay. Well, I'm getting desperate here to give away one of my flowers. Was there any other question that I asked? Looks like you got to be prepared for next week. Now, I know when we have a webinar, we pack a lot in a short amount of time. So we have those Mont Guides that you can review and have additional information. So if your memory is not like an elephant's head, that's a wildflower. We've got 50 Mont Guides. Yes, I could proudly say that MSU Extension has 50 Mont Guides in the estate planning area. Now, granted, most all of them are Montana specific, but there are a few in there that are more generalized, or they refer to federal laws as well, like the ABLE accounts. Don't forget, and that's what the forget-me-nots are reminding me to say, is that some of these, all of these are also available at your county extension office. So you can give Mandy a call and say, hey, I want some of those. And if she's not there, I bet there'll be somebody else in the office that would be glad to run those off for you. Now, next week's topic, we're going to dig a little bit deeper, and we're going to see what you can do with the will and what you can't. So let's take a look at our special guests that we're going to have. And I think you've got some questions ready there, Mandy. And let's see what Kelly and you can provide us with more information.
Thank you, Marcia. So, Kelly, were you able to find us a spot to log in and join us?
Yep,
I
I'm
see.
here.
Okay,
Oh, she's
excellent.
there. Good.
Okay, yay, thank you. Thank you so much for being able to do that. So my first question for you is, how did you choose a guardian for your minor children?
Well, when my husband and I first started talking about it, our biggest thing was trying to find a family member that, sorry, I just realized I was covering my camera. Um, we were trying to figure out somebody that was going to raise the boys in a similar fashion to what we raise our children. And so that was kind of where we started, and we picked my husband's younger brother, who also has children the same age, or close in same age as our kids.
And was it easy for you? Did you and your husband agree, or was it easy for you guys to agree?
We came to an agreement, yes, after a lot of discussion, because it was hard for me to say what. It was my biggest concern is where do my family fit in to that decision, and how are they going to then be able to have a part of the boys' lives.
Did you name some successors or some backup guardians, conservators?
We have not yet.
Uh-huh.
So I know that when we were planning, my husband and I are both the oldest, and we had kids before any of our quite a ways before any of our other siblings, and even we're married, and so making those decisions was really difficult. And I know we were young. We're from a very blended family, very blended, and so we had a lot of different options to consider, even with our parents and our siblings, and we decided that we finally decided on on my sister, and because we really wanted to protect their grandparents and let them stay in that grandparent role. But then, like I shared earlier, and she knows I'm going to share this, that my sister has a great heart, but she's not awesome with money. So we definitely wanted someone to help her manage that as well. And we
Did
had
you, I'm sorry, did you name the same person as guardian and conservator, or do you have two separate people?
No, my brother-in-law will be the guardian and conservator.
Okay.
Yeah.
Mhm. Yeah, in my family, it was similar that my sisters wanted me to be a part, and I said, okay, I can do money. I think I would make a really good conservator, but I didn't feel that I would make a good parent. So they were willing to honor that, and boy, did I have relief when all my nieces and nephews reached age of majority. And have families of their own, but I'm carrying through my duty to get nieces and or my nieces and nephews to take care of estate planning for my grandnephews. There's four of them. And okay, is there a will? What have you done? And so I send them some of the stuff I update now and then. Have you shared any of your experience with other family members, Kelly, of the challenge of going through all that discussion?
Mostly we've just talked to my brother-in-law, just kind of expectations of what we would want the boys to experience in life. We haven't spent a lot of time talking to my family about it because we all know that it's going to cause a lot more hurt feelings of us not choosing anybody within my family. And so I haven't, but my mom and dad know, but my brothers don't.
Uh-huh.
Yeah.
That
Probably
is
not the
until they
best
listen.
idea.
I've encouraged all of my sister and sister-in-laws with minor children to definitely make sure that they at least have named a guardian. And it doesn't have to be me, but I want you to please name somebody. just to make sure, because like I said, we have enough family and a blended enough family that you want to make sure that your wishes are honored. So Kelly, I have another question for you. What do you know now that you wish you'd known then?
Oh wow. Really the conservatorship aspect of it. My husband and I own a house. And so we never really thought about that aspect of it of, where does that go? Or anything like that as far as like how is that going to help the boys or hinder the boys? And they're still pretty little. They're only 9 and 7 now. And so I wish that we would have put a little, and well, obviously we can go back and add more information, but we need to discuss like where everything goes and how to set up that trust for the boys so that they are hopefully set up for better after they turn 21.
That's awesome. And I would say we would be similar. I wished that although we set up a conservator, I think looking back at it, we maybe tried to overthink it, especially with the assets that we had at the time. We maybe made it more complicated than it needed to be just because we were concerned. So I think we might have overthought it. And then we found ourselves in this transition space right now where our children aren't minors right now, but really don't have a permanent address that's not ours. And so what does that look like, and what's the appropriate changes to make for them?
Yeah, and that's the thing about estate planning. It's just not a one-time thing. Families change through time. And that means we have to update our wills. We need to maybe, you discover new things about the family, and some people grow up and they're different than you thought they'd be. And it's that discussion that needs to happen. And it's almost like somebody has to take the bull by the horns, as they say, and talk about it, and maybe even set up a time and say, okay, let's have this discussion. We don't need to have an answer right now, but the important thing is let's have the discussion about that.
And that is a great point, Marcia. I just want to share, which maybe I'll get kicked off as a panelist. Maybe I shouldn't share this, but I recently found out that my husband and I had a will written because of a class I took with Marcia, and I realized that if there was any sort of a dispute in my family about who would become their guardian, they would go into foster care or could go into foster care, and we definitely didn't want that. So we had a will written. And I recently found out, as I was discussing, we need to make some changes because they're both older now. I did not realize my husband didn't actually sign his, and I'm not sure what kind of implications that would be. So he has an unsigned will that he, for some reason, kept in the console of the pickup, which is not awesome. I know Marcia's gonna kick me off. I'm getting a call after this. So I'm gonna just put it out there. Maybe make sure they're both signed and accounted for and filed in an appropriate place.
Yes, and this brings forth an actual situation in Montana where, here's this gentleman that died, and everybody knew he had written and signed a will. And where was it? They looked all over the place, safe deposit box, all those kinds of things. And 5 years after the probate was done, they were going to sell the pickup. And guess what was in the glove compartment? There it was, but it was too late. And the will was different than the state of Montana did it. So here's my lecture to Mandy. That will is useless when it's not signed. And so even though it's old, and when we sign a will and we have it done by an attorney, usually has to be 2 witnesses if it's typed. And those 2 witnesses, then we have a notary, and the notary makes sure that these 2 people are who they say they are. And what that does is make the will self-proven. Okay. And once it's self-proven, when it's submitted to probate, we don't have to call in the witnesses to say, oh yeah, Mandy was of sound mind that day, and Kelly Kelly was of sound mind that day. So very seldom will you let an attorney let you out of the office without signing it like that, because they have discovered that. And there's another story where a gentleman was on his way to sign his will. And you can guess what happened. He had a heart attack and he died. So let's not wait around. Let's get that booger done. And, I realize we can change it. And that may be true in the future with you there, Kelly, of looking at the kids being 9 and 7. And we still got some years left. And, a good discussion, and it's not fun, but okay, we picked out this brother-in-law. But what if he is killed in a car accident? Okay, so maybe we start the discussion now, just in case, so that we're not making a decision in a crisis mode and feel like that we have to hurry up and get it done. So, well, thank you very much. Do we have any questions, Carrie or Mandy, since I can't see them? Are there any others?
Marcia, I don't see any questions.
Okay, well, thank you. And Mandy doesn't either. So I see that we're getting right up at the hour. And I'd like to thank our 2 panelists for making an appearance today and giving us some real world experience about what estate planning is and was for them. So I hope it still is, because it's a process. You're doing it, I'm doing it. And I'd also like to thank Mandy for being a co-host. And we look forward to seeing all of you next week. And Mandy, what was our topic? Something about wills, I think, a deep dive into what you can do with a will and what you can't.
Yep. So it's going to
Okay.
be a really good look.
Yeah. So in the meantime, be safe, keep healthy, so that we can gather together and see one another and learn again. Bye-bye. And thanks to Carrie as well.